All right. Hello, everybody, and welcome. This is one of our final events, almost, for our First Amendment Days celebration this week. And we want to thank you for being here. Those of you who are in our audience and those of you who are on Zoom, welcome as part of our First Amendment Days celebration. So let me just say a word or two about First Amendment Days. So this is our 20th year of taking anywhere from 1 week to 1 day to celebrate and educate about the 5 freedoms of the First Amendment. And so my first question at each of my events so far has been to ask what is the First Amendment? Do you know what your 5 freedoms are? Because we kind of have the hybrid approach here, I'll let you off the hook and I will tell you that our First Amendment protects not only our freedom of speech, which tends to be the one that we think of most often, but also freedom of the press, freedom to petition the government for a redress of grievances, freedom to peaceably assemble, and then the freedom of religion, both to practice the religion that we believe in and also to not practice religion if we so choose. And so we think it's pretty special here at Iowa State that we take some time out to think about these freedoms and how they work to create the foundation of our democracy. So tonight we're going to be talking about New York Times versus Sullivan, which is a landmark case that protects many of those aspects of the First Amendment that I just talked about. We'll talk just a little bit more about the case here in just a second. Before we do that, I want to let you know if you have questions, those of you who are in Zoom land, please share those in the chat and we have a moderator who will help share your questions, and you don't need to wait until the end of our discussion. Feel free to ask those questions as we go along. And we'll probably wrap up around 6:20 and try to conclude at 6:30 this evening. So don't wait to ask your good questions. Because of the panel format, I'm going to ask each of our panelists to simply introduce themselves, and then we'll get started with our first question. So without further ado, I'm going to sort of turn my screen here and ask George to get us started.
Well, thank you, Professor Roosa, and thanks for inviting me to the panel, and thanks to everybody for coming. I mean, it's really great to be able to talk about the First Amendment. It's a big part of my life. I graduated from the journalism school at Drake University in 1977, went into broadcasting, and wrapped up my journalism career, the early stages of it anyway, in the mid 80s actually, and went into marketing to make a living and was in advertising and marketing, which a lot of journalists wouldn't have any affinity for, but I had to do it to get by basically and to raise a young family. And then I took that towards retirement and checked out as soon as I possibly could to enjoy, what I want to do. And one of the things that I wanted to do was get back to broadcasting. And that's what I'm doing with Podcast by George as a kind of an indie journalist. I kind of had to keep my head down in the marketing world and keep my nose to the grindstone and keep my opinions to myself if I was going to make a good living. And when I came out of my professional career and went into retirement, I started to look around and dig a little deeper into the news and discovered that things ain't what they appear to be. The way that I put it to people is that we're not getting, anything close to the whole truth, the truth, and nothing but the truth. It's just, there are a lot of factors in play. We'll talk about some of those today, I'm sure. But that's kind of what I want to do with the podcast. I wanted to get back to something that I was good at, that I quit doing, not because I wasn't good at it, but because I had to. And I always felt that I wanted to kind of pick it up and run with it again. And that's what I'm doing with Podcast by George. And that's the show name. My name is George A. Clark, and I always like to throw the A in there because it represents for my grandfather, who I was very close to, and he was a World War I hero, actually. So I always use George A. Clark. You'll see that on the website and on the promos and stuff. But that's kind of the story, kind of the genesis for Podcast by George.
Thank you.
Yeah.
Hey, Jeff.
Thank you, Julie, and congratulations on 20 years of First Amendment Days at Iowa State. It's a pleasure to be back on campus. I graduated from the Greenlee School way back when, and worked in newspapers for 4 years after I graduated from journalism school. both here in Iowa and in my home state of Utah. And after 4 years, I was covering the federal court beat, got to be pretty good friends with a federal judge in Salt Lake. He encouraged me to look into law school, and I applied, and eventually I went to law school, graduated, and started a career in First Amendment and media law, trying to combine my experience as a working journalist with being a lawyer. And I've been privileged and happy and thrilled actually to have done that work for the last 30 years, representing journalists and news organizations in Utah on a broad variety of issues, defending defamation lawsuits, filing lawsuits to open up government records, to get court records. So it's been my life's work, trying to keep government open and accountable, and keep the press free, and keep journalists independent so they can do their work. So it's happy to be here and look forward to the discussion.
Jared.
I'm Jared Strong. I'm also an Iowa State alum, and I must say I'm very uncomfortable to be in this room because I've bombed a bunch of math tests in here before. You didn't tell me the location before I agreed. I'm a reporter for Iowa Capital Dispatch, covering agriculture and the environment. Prior to that, Iowa Capital Dispatch is an online nonprofit news organization made of former newspaper reporters, and we produce all of our, we publish all of our, we make our stories available for free online, and then make them available for republication in newspapers and radio stations and TV stations across the state. Prior to my time with Capital Dispatch, I was a reporter for more than a decade at the Carroll Times-Herald, and for some years at Des Moines Register before that. And on a personal note, today is the last day of my 30s. So if anyone on Zoom wants to go over to Welch Avenue Station and open a tab for me, I'd very much appreciate it.
Very good, very good. Well, we'll do our best to make your birthday memorable here, at least the day before your birthday. All right, so I mentioned before that our discussion today is going to be about New York Times versus Sullivan. And I'm going to ask Jeff, the attorney here in the room, to share with us, just remind us what New York Times versus Sullivan is all about. And then I'm going to be asking the panelists kind of what the significance of that case has been in your work so far. And then ultimately, we're going to talk about what if New York Times versus Sullivan didn't exist or was changed, what would be the impact? So Jeff, if you could get us started with an overview.
Sure. So a lot of people don't know, but New York Times versus Sullivan was not over a piece of reporting. It was over an advertisement, a full page advertisement that ran in the New York Times in 1960. And so to understand the case, you really need to understand the cultural, political context at the time. So this is 3 years after Brown versus Board of Education, but before enactment of the Civil Rights Act. And so it was a time of massive resistance in the South to Brown versus Board, to integration of public accommodations. And the New York Times, of course, was covering this very closely. They had a fleet of reporters down in the South covering the civil rights protests. And the advertisement in question was placed by a group of supporters of Martin Luther King and the civil rights protesters in the South, and included a number of really notable figures, Harry Belafonte, a number of other famous actors and actresses, civil rights leaders, including Ralph Abernathy, Fred Shuttleworth, J.E. Lowry. More than 60 people signed this advertisement, and basically the ad criticized the conduct of the law enforcement authorities in Montgomery, Alabama, concerning the treatment of the civil rights protesters. And it was titled "Heed Their Rising Voices." And the Commissioner of Public Safety in Montgomery, Alabama, was L.B. Sullivan. He did not care for the ad. He did not care for the civil rights protesters. And he filed a libel lawsuit in circuit court and state court in Montgomery, Alabama, claiming that the ad had libeled him even though he was not named in the ad. The ad just referred to police generally. These days, that would be enough to get a lawsuit like that dismissed, because to be defamatory, the statement has to be of and concerning a specific individual or a small enough group that you could identify that individual. This would not have satisfied that test. But he sued anyway, and he asked for and received a libel judgment against the New York Times of $500,000. At the time, that seems like today, that's kind of not much, but back then, that was a lot of money. It was a record libel judgment in the state of Alabama. Nothing had even come close to it. And of course, a series of such judgments would, essentially bankrupt even a publication as well-heeled as the New York Times. Not to mention the smaller papers in the South that were trying to do that type of journalism. And so the judgment was appealed to the Alabama Supreme Court, which hastily and perfunctorily sustained the judgment. And then from there, the New York Times appealed to the United States Supreme Court. And so when it got to the United States Supreme Court, it was 3 to 4 years later, 1963, 1964. And the strife in the South had continued. And so the justices, they read the newspapers, they knew what was going on in the South, thanks to the reporting of organizations like the New York Times. And that was the prism through which they looked at this defamation lawsuit. And for context, at this time in 1964, there were no constitutional limitations on defamation lawsuits. There was no First Amendment limitations on libel lawsuits. So the court was confronted for the first time with whether there ought to be, whether the First Amendment imposed some limitations on a public official suing the press for speech that was critical of their official conduct. Okay, so this wasn't speech that was critical about L.B. Sullivan's private life. This was about, even if you accept his theory that it was about him, it was about official police conduct. And the argument that was made by the New York Times attorney was that there ought to be some First Amendment limitations on such actions, because the First Amendment at its core protects speech about the government, and the government shouldn't be in a position to retaliate and enforce ruinous monetary judgments to silence critics, because that's essentially what L.B. Sullivan was trying to do. He wasn't concerned about his reputation. He wanted to send a message to the civil rights leaders and the press that was covering them that I can do this to you, I can silence you, and that would essentially chill speech, chill reporting about this very important issues going on in the South over race. And so that was the argument for the Times attorney. The argument for Sullivan's attorney was libel law has never been a constitutional matter. At the time of the framing of the Constitution, it was English common law that controlled libel actions. America adopted that under English common law, as in Alabama at the time. If the statement was defamatory, intending to injure someone's reputation, damages were presumed, falsity was presumed, and the burden of proving the truth was on the defendant. Okay, the burden wasn't on the plaintiff to prove falsity, it was on the defendant. And so that means that almost every case is not going to get dismissed at an early stage, because you're going to have a trial over what was factual, what was true, and what was not. And of course, that's expensive, and a lot of smaller papers could not afford that kind of litigation. So what would they do? They would steer away from that line. They would not report on those vital issues that need covered. But that was the law at the time. And so the import of the decision, which was a 9-0 decision, it was a unanimous Supreme Court decision, was that the First Amendment does impose limitations on the ability of a public official to sue the press or anyone who makes a statement that's critical of their public functions. And the test that they created is the actual malice test. And the idea was that the First Amendment needs to provide some breathing room for the press to do its job. And the core of that is covering the functions of government. And when the press is covering things, reporters are human, they make mistakes. There are going to be errors. And the idea here was that if you make an error and it wasn't intentional, it wasn't knowing falsehood, that would not be enough to sustain liability by a public official suing the press. So it created some protection for the press to make good faith errors and not be subject to ruinous, financial judgments by public officials suing them. And since then, I mean, it's become one of the great landmarks of press freedom, not just in the United States, but in the world. If you go on the United States Supreme Court website, there is a list of they call them landmark decisions. And you have Brown versus Board, you have Mapp versus Ohio, one vote, one person, one vote. You have a number of these critical decisions, and New York Times versus Sullivan is there, right up with the rest of them. It's really a beacon of press freedom, and it's what has allowed for the citizens in this country to get the kind of news that they should be getting regarding public officials and their conduct.
Thank you. All right, I'm going to jump over to you, Jared, first and ask you to share with us. So we know Sullivan didn't really necessarily feel libeled. He wanted to send a message. He wanted to chill speech. Have you in your reporting career had situations where you've been able to report on public officials because you had the protection of Sullivan behind you? You didn't have that fear of I shouldn't report this story because I know I know what I need to do here, if that makes sense.
Yeah, so I guess I didn't say this in the introduction. I'm here not because I'm an expert about any of this, but because I've been sued for libel by a police officer in Western Iowa, in a small town in Western Iowa, who had some dubious relationships with teenage girls and women, and was eventually forced to resign. And when we published a story about it, we got sued basically the next day for it. So, it's not often that I, in my day-to-day reporting, think about this court case and think about the the protections that it affords me. I just wanted to, because I've always wanted to do this, you'll have to let me indulge, or you have to indulge me for a second. So the last time somebody asked me about this court case was during the lawsuit proceedings. We went through depositions, which if you're not familiar, it's basically an interview that's under oath. And the opposing attorney, the attorney who had sued us, was quizzing me about what I studied at Iowa State. And it had been a few years. So we jump in here. He noted that I had taken a journalism law course. And I've always wanted to do a theatrical reenactment of part of this deposition. So here goes. And he had a very bombastic way of talking, which was strange because it was just the two of us talking to each other. But, and so you certainly would have studied New York Times v. Sullivan in that course, wouldn't you? And sorry, professors who are in the room or watching, as my response was, I don't recall what we studied. And he said, well, you understand the term public figure was the essence of that court case. Do you remember that study at all? And at this point, because I just told him that, I don't remember what I studied, I did not know what I was going to say. And luckily my attorney jumped in at that moment and said, I'm going to object because not to show my superiority on knowledge of New York Times, but I believe it's a public official case, not a public figure case. And sorry to be such a jerk on you, Mr. Van Dyke. That's fine. There are other Iowa cases that talk about that distinction too, so we'll argue that another point. And my attorney then said, I think we'll have many days to argue that. And at that moment in my head, I'm like trying to be very serious, but I'm like, boom, yeah. I still don't know what we're talking about. My attorney just, yeah, anyway. So yeah, we, in that case, we never really had to drill down into that because the judge ended up dismissing it because he ruled the story was accurate. But as Jeff said before, you know, reporters are human, reporters make mistakes, and especially for that story, a lot of it was built on public documents, but a lot of it, especially with the relationships that the officer had cultivated, a lot of that was based on me talking to people and trying to ferret out the truth, who was telling the truth and who was lying. So, you know, maybe that always leaves open the possibility that something in my reporting could have been false. You know, basically this case provides that protection that as long as you're doing your due diligence to try to figure out the truth, you're not going to be held, you know, financially liable for it. And in that case, you know, I mean, a lawsuit like that can sink a small newspaper. It's incredibly, I mean, with the state of the newspaper industry at large right now, I mean, it's tough even for big newspapers, but especially small ones. If you have the threat of litigation hanging out there, it's definitely a disincentive to try to hold the public officials and public figures accountable.
Very good. Thank you. All right. And congratulations on the dismissal too of your case. And also now your newfound expertise on New York Times versus Sullivan. All right, George, let's come over to you. And, you know, maybe not specifically how New York Times versus Sullivan has protected you, but in general, how do you approach the reporting that you do when it comes to public officials?
Well, if it weren't for New York Times versus Sullivan, I probably wouldn't be doing it for the reasons that Jared delineated. I mean, it would be catastrophic to somebody in my circumstances to be sued frivolously without merit on libel grounds. So that's why it's great to have this high bar, this extremely high standard set down by New York Times versus Sullivan, because it would eliminate independent journalists to a great extent. And I think they're extremely valuable more now than ever, because again, talking about my own experience and background coming into this in retirement, I'm focusing on truth telling as I see it. I'm trying to enlist the services and the guests on my show that are telling the truth. And I'm trying to give a left-wing perspective, which is where I'm at. I mean, I'm on the left side of the political spectrum. I'm not going to lie to anybody about that, but I feel that the left is underrepresented, that our perspective and viewpoint isn't getting out there. And of course, that's diametrically opposed to the people on the right and the moneyed interests that would probably, you know, have an axe to grind if they could. They'd like to put people like me on a small scale, but also on a larger scale, people like, you know, Lee Camp and Jimmy Dore and, you know, even Joe Rogan and people like that out of business. And I'd like to see those people stay in business. I'd like to see them stay on the air and offer a perspective that's not being heard in a lot of places, particularly on the top 3 topics that I cover on my podcast all the time, which are climate, war, and healthcare. And they're kind of in that order. And my viewpoint and what I say on my show is that the left-wing perspective on those issues, the true left-wing perspective, really is not being heard. You're not, you know, Chris Hayes on MSNBC himself said he devoted the entire segment once to climate. It just didn't rate. The IPCC came out just recently with the UN and said, if we don't do something about this in 2 generations, it's game over. I mean, we've got to focus on this. This can't be advertising driven. It can't be related to ratings. I mean, we've got to move. People have got to become aware about the climate and the war, even the war that's, you know, dominating the headlines right now in Ukraine. I don't feel that the movement for a ceasefire and a movement for negotiations is getting heard as much as the militaristic, you know, the push for war that these indie journalists can provide. But they'll not be heard if they can't be on the air, if they can't be in print, because they're libeled out of business as far as lawsuits are concerned. I mean, it has an extreme chilling effect. You'll hear that term used a lot when it comes to libel law, but I mean, it's so chilling, it's freezing in my circumstances and for people like me.
Thank you.
Yeah.
Right, Jeff, I want to hear your perspective, especially as someone who's been practicing in this area for quite a long time. And then if you would, I'd like you to move us into sort of why we're here today. Why are we even talking about New York Times versus Sullivan? Is there a threat to this decision?
Yeah, so I'll take the second one first. The reason that we're talking about the threat to the New York Times versus Sullivan is now we have two justices on the United States Supreme Court who have expressed a view that Sullivan should be either overruled. That's Justice Thomas. He said that quite clearly, that he believes that Sullivan is inconsistent with his originalist theories of constitutional interpretation. First Amendment provides no limitations on common law torts such as defamation, and therefore Sullivan should be overruled. That's Justice Thomas. Justice Gorsuch, and that view was expressed in a case called McKee versus Cosby, 2019. So that's what, 3 years ago. And that was a case where one of Bill Cosby's accusers, who was claimed that she'd been sexually assaulted by Bill Cosby. Cosby denied that, made some statements, and she brought a defamation action against Cosby. And it got thrown out on actual malice grounds. And so Thomas dissented. The case was never heard at the Supreme Court, but they were trying to get it there. And the Supreme Court usually accepts a very, very small percentage of cases. They denied certiorari on that case, but he dissented and he rolled out this critique of New York Times versus Sullivan on originalist grounds and expressed his view that it should be overruled. And the second one is Justice Gorsuch, just last year in 2021, same sort of circumstances, a case that they were trying to get to the Supreme Court. He had sort of a kind of a meandering dissent from the cert denial, where he didn't outright say that it should be overruled, but he said he expressed some very serious misgivings about it. He didn't say how he'd come out, but basically his critique was a prudential one. It had nothing really to do with originalism like Thomas. His critique was, yeah, we needed Sullivan back in the 60s when the civil rights protesters were getting hammered on by these Southern juries and they were hammering the Northern press, but times have changed. We're in a different media ecosystem now. We have the internet that provides, a variety of viewpoints. Everybody's their own publisher. The economics of the industry have changed, and therefore the rationale of Sullivan is no longer valid. All those assumptions, I think, are false. I think he's confusing content. He's confusing platforms with content creators. I mean, Twitter and Facebook and those are platforms, and people making all those comments that he's talking about, who are their publishers, they're not news organizations. Okay, they're not doing the work that Jared and others are doing. So, the idea that just because we have so many more opportunities to speak somehow undermines the rationale of protecting journalists that speak critically or provide a forum for speaking critically about official conduct, it makes no sense to me. And in terms of the critique of the internet, he said his idea was that there's just this garbage of disinformation out there, and Sullivan turbocharges that. It incentivizes that kind of thing because you can't get at those people. Well, again, Sullivan has nothing to do with that. The reason that happens and the platforms have no liability is Section 230 of the Communications Decency Act, which says that Twitter and Facebook and those internet platforms are not publishers. You cannot sue them for the defamatory content on their platforms. You have to go after the people that post the information on Twitter and Facebook, etc. They're the publishers, not the platform. So the court has nothing to do with that battle. That's a regulatory issue for Congress. Congress could change the immunity provided under Section 230 of the Communications Decency Act, put more obligations on the public on those platforms to police content. But that has nothing to do with Sullivan. And so I think that Gorsuch's views is just proceed from a number of false assumptions about about the role of the media. And one last critique of his, the Gorsuch view is that it incentivizes journalists to just wing it and say, oh, we've got Sullivan. So we don't really need to dig deep. We don't need to call that source. We don't need, and that just betrays a shocking ignorance of how journalism works and how newspapers work. I mean, as a lawyer who defends news organizations, I can tell you that not in 30 years practice has ever occurred to me to counsel a client that, hey, don't worry about it. Sullivan's got you covered. You don't need to check your facts out. We got Sullivan. It's ridiculous. I mean, it's just not the way journalism works. And plus, you want the reporters to do that because if I'm in a libel case, I want to be able to show that that reporter did everything that they could to verify the accuracy of the information. And the only way that my client is going to be in trouble is if they knew it was false and they went with it anyway, or they had serious doubts about it and they went with it anyway, which is very, very rare. And in those cases where that happens, then they should be held accountable. That's the beauty of Sullivan, is that it hasn't discouraged public officials and public figures from suing the media when they believe that they have a case of actual malice. Look at the Sarah Palin lawsuit against the New York Times. Went on for 5 years. She got a trial and she couldn't prove actual malice, but she at least got to trial. She could make her case. And so those lawsuits are coming. And I just fear that if you roll back Sullivan and over the 30 years of my practice, writing letters to public officials and large companies and sending them back a letter saying, hey, if there's something wrong, factually wrong with the story, I want to know what it is, because we'll correct it. But if you don't, then we're standing by the story, and they know that we've got the protection of Sullivan if we have to end up going in and fighting it out in court. So it's hugely important as a legal matter in terms of providing the breathing room, but the sort of the day-to-day, counseling of the newsroom, it's not like lawyers are saying, don't worry about it, we've got Sullivan. It's just not the way it works in the real world.
Yeah.
Well, this is a question for Jeff, and he had a great overview. A lot of people wouldn't realize that the Sullivan case came out of the South, and it came out of Jim Crow, and it dealt with advertising. And the history of this is very interesting. And history is always the best precedent, and this is what lawyers deal in, the world of precedent. So since Sullivan, is there any precedent, any historical thing that people can point to that say this individual has been greatly harmed because Sullivan exists? To me, the best defense of Sullivan is that it works, and it's worked admirably since 1964.
Yeah, that's a really good point, George. And I think that if there's a fault line in Sullivan, it's not Sullivan and the public official doctrine. I think even Gorsuch, I don't think, would go there and dismantle the protections that the press and speakers have for lawsuits filed by public officials concerning official conduct. I think it's the extension of Sullivan and the Butts case and the Gertz case to public figures. And the rationale of extending those protections to public figures is that public government is not the only powerful actors in our society, right? We have corporations, multi-billion corporations. We have people that have a large amount of power and resources and wealth in the private sector, and they're essentially exercising that power. They have access to the media, so they can get their point of view across, and that those powerful corporations and private figures that rise to the level of what they call a public figure ought to be held accountable just like public officials. And I think that makes sense to some extent, but when you're talking about people like Britney Spears or the Kardashians
Or Palin,
and treating them as public figures, the rationale of Sullivan really doesn't apply that well, because the rationale of Sullivan is self-government, essentially, that we need to hold government accountable, and you need to be able to criticize government if we're going to have a functioning democracy. And a lawsuit by the Kardashians against a press and their role of public figure, I think if you see any rollback of Sullivan, it'll probably come first in the public figure realm, maybe curtailing the protections that speakers have with respect to public figures in defamation lawsuits, but not probably public officials.
Interesting. Okay, Jared, I'll give you a heads up. I'm going to be coming to you and asking, you mentioned due diligence. I want you to walk us through an example of how a reporter would pursue that due diligence. But before we get to that, I don't want to forget to ask Jeff, you mentioned changes to Section 230. We've also heard threats of, or demands for changes to the libel law. Is there a way to change libel law through, the legislature?
Do you want me to take that
Yeah.
first?
Mhm.
Okay. Yes, I mean, libel law is a creature of the common law, sort of judge-made decisions built up over a number of years around the tort of defamation. But in many states, it also is defined by statute. And so a legislature could come in and change the law of defamation in their particular state. It's not something that the federal government can do. When President Trump said, well, we're going to loosen up the libel laws, everybody just scratched their head like, what are you talking about? Federal government doesn't make libel laws. They're creatures of state law. So, and that's sort of this interplay between judges sort of incrementally making the law and legislatures. And so certainly, if the legislature wanted to come in and make it easier for defamation plaintiffs to sue, they could do that, but they would still be these First Amendment protections that we have as a result of Sullivan and his progeny as applied in the public figure cases.
Okay, thank you. Just want to clarify that. All right. Jared, walk us through what the process is for a reporter in doing their due diligence.
Sure. Well, step one, if someone is accused of any sort of malfeasance and you're reporting on it, you have to contact them and give them a chance to respond to it, right? So that's an absolute requirement in my mind. And just to go, I'll use the police officer case. We'll keep going back to that because it's probably the most interesting example and that I can come up with at this moment. But so in that case, I reported the story for a couple weeks, and then I met with him. We had a 40-minute meeting at a public park that one of my coworkers monitored for fear of my safety. He was much larger than me. So I walked him through the major points of the story of the article I was preparing, and he disputed various things in it. So then I spent a period of days going back to my sources and going back to documents to double check, what he was telling me against what everything else was telling me. So yeah, I mean, it's a matter of being diligent about, evaluating the whole situation, not necessarily taking, people's word for something, and just checking things out as much as you possibly can.
Okay, thank you. All right, George, I want to circle around to you now. And you mentioned that you're an independent journalist and you're a podcaster. Well, New York Times versus Sullivan involved the mighty New York Times and a newspaper. So how do you see your role fitting in terms of, holding our public officials accountable?
Well, again, going back to that big three that I cover all the time on my podcast, climate, war, and healthcare. On the issue of war, the New York Times is an example. They're the big dog. Everybody looks up to them, and thank God that they're involved in this fight for the First Amendment and for libel. But if you just relied on the New York Times, you would be supporting every war since Vietnam. The New York Times literally has done that. They have been on the record in their editorial pages supporting war. They've been wrong my entire lifetime. So it's up to people like me and people on the indie left to point this out and to push back against mainstream media, which I think has failed miserably. And the best example of that, and I don't want to get all political on you, but it has to do with Iraq. My God, that war, 1 million people were put in the ground, innocent civilians, men, women, and children under a false flag, under a search for weapons of mass destruction that did not exist. Well, the New York Times supported that war. You know, they may have evolved as the war went on, but their editorial pages pushed for that. So those indie voices, those people, and indie voices is maybe not a good way to characterize it, but the independent journalists need to be heard, like I said earlier, now more than ever, because we're looming, we're on the precipice, they're telling us, of World War III. And these voices are simply not being heard. I had a podcast on just this past week with a film clip of a guy that people think is a real lefty. It's Ali Velshi of MSNBC. He's calling for war. He wants the United States to go in on the ground and fight in Ukraine. Well, if we do that, if we shoot down planes over a no-fly zone, if NATO forces go into the Ukraine, you're looking at World War III. Sean Penn is considered to be a darling of the Hollywood left. People think that Sean Penn's a real lefty. He was on one of the internet platforms, I think on Twitter this past week, basically calling for maybe some smaller nuclear weapons could be used. I mean, people need to jump up and down, scream and shout about that kind of thing. And that's what I'm doing. And that's what I'm doing with my podcast. And again, I'm just a small piece of this puzzle, but there are bigger people than me that are doing that and using these internet platforms to do that, because they've been marginalized. And I'll use an example here, kind of a hero of mine, Chris Hedges. He was a war reporter. He was a Pulitzer Prize winning journalist with the New York Times. He was reporting on the war in Iraq. They didn't like the way that he was reporting on it, and they fired him. And so he was marginalized, basically. He wasn't blackballed officially, but he couldn't get a gig. And so he was marginalized into the world of RT, Russian television. That's kind of how it works. You get marginalized and then you get demonized. And Chris Hedges is a great left-wing voice that basically doesn't have a platform except for the internet left. So I don't know, that's kind of a rambling response to your question, but that's why I think it's so important that these voices not be infringed upon, that they continue to have a really strong protection under the First Amendment, and that they be shielded, particularly from frivolous libel suits.
Right. Well, and that's also why we called our session Attention All Content Creators, because I think you're a great example of why everyone needs to be concerned about some of this discussion. I know we have a couple of questions on the chat, and we may have a couple more here in the auditorium. So if you are willing, we'll go ahead and take those questions. I predict we're going to go over time just a bit, but let's hear our first question.
Okay, this one is from Mark on Zoom, and this question is for Jared. Why is investigative journalism important? And do you think the power of the internet helps or hurts the impact of such efforts?
Well, I mean, it's important because, you know, I view my job primarily as informing the public. And, you know, good reporting is the best way to inform the public. As far as the internet's effect, I mean, I would say, you know, there's more, a negative impact of the internet would be that there are just more voices out there. It can be challenging for people to navigate the amount of information that's out there now. But on the flip side of that, it also gives us more reach for our, you know, for the articles that we write, for the reporting that we do. And I think that it enables, it's a big enabler of our ability to report, just because information is so much more readily available.
Yeah, so then we also have another one from Mark. It's kind of a three-part question, but it's for George. So I'll take the first part and then I'll give you the second part because it's kind of a lot, but it's all right. So George, do you believe you possess a greater level of responsibility in both entertainment and informing your audience as a podcast host? And then the second part is, do you think all content creators should hold the same level of responsibility? And why do you think that that sense of responsibility has been tossed out the window in today's media climate?
Okay, so I'll answer as best I can. The first part of the question has to do kind of with that blur between entertainment and factual information, entertainment news. Is that the context of that question? Is that the way that you? Okay, this goes back to my days, even in the newsroom, when I was rewriting National Wire copy and chasing ambulances and what I was doing back in the day. But I was always a firm believer in you can be the best fact teller, you can be the best truth teller that there is. But if nobody's listening to it, what good is it doing? I mean, that's the reason that we do this, is to improve the circumstances of the world, basically, of humanity, by telling the truth. So you need to put it in the context of being entertaining enough anyway, that people will want to seek it out and people will, take it to heart, and that people might act on it. So that's kind of and I used to be that way when I was writing newsroom copy back in the day. My stuff was always a little bit more, and you can believe this if you hear my podcast, but compared to the other reporters, it was always a little bit more outlandish. And the reason for that was that, my headlines and that type of thing, to draw people in, to get them to pay attention so that they would benefit from the truth that was, in the journalism. So that's kind of that blur. And I think it's a necessary thing. I mean, if people don't pay it, if they don't read it, if they don't watch it, what good is it? So, and that's a big thing in my podcast. So does that answer the first part of the question, you think?
Yeah,
Okay. And the second part, again, I'm not sure I got that.
it's okay. Do you think all content creators should hold the same level of responsibility? And why do you think that the sense of responsibility has been tossed out of the window in today's media climate?
Yeah, I think they should be held responsible. My feeling of it is, I mean, you've got your libel laws and the Section 230 situation we talked about. There are plenty of other laws on the books that can be enforced if you're harming someone, if you're actually hurting somebody. But other than that, I'm a huge advocate of free speech. I don't believe that words harm. I believe that actions harm. And if you're harming somebody, use the laws that are on the books to go out and right that wrong. Don't censor, don't deplatform people. My solution to bad speech, I'm not talking about hate speech, but I'm talking about bad speech, speech that isn't truth, is by overwhelming it from the truth-telling side. I mean, that's what I'm trying to do. I mean, the solution to bad speech is good speech. More. I'm a big advocate of openness, transparency, and taking advantage of the full rights afforded us by the First Amendment. So I hope that answers the question. Yeah.
Let's see, I'd be curious, Jeff, of your reaction to that idea of entertainment kind of getting mixed into the news, and what the responsibilities are, especially of news organizations in that environment today.
Well, I agree with George that making it interesting helps, because then you've got eyeballs, you've got people listening, and they're getting valuable information. So that's all good. I think where the fault line is, and I think you could see it in the Smartmatic and the Dominion voting lawsuits. These are the two software companies that provided software for some of the voting machines, and they were accused by some of President Trump's lawyers and others of engaging in fraud and basically a bunch of misdeeds, and that their software was junk, and that they knew it was, and they were participating in this great fraud. And they have sued, these companies have sued the lawyers, the other spokespeople for President Trump who were making these statements, as well as the Fox News personalities, the news hosts who were making these statements, and Fox News as well. And so to me, that raises this kind of issue, are these people that are sort of these news personalities, they kind of straddle this line between opinion and news and entertainment. And are they just giving voice to these people that they're interviewing, some of whom are making these statements that are alleged to be false and defamatory about the voting software? Or are they really more not acting like journalists, but more like people that are adopting that view and pushing it. And so it's not just, I'm giving you a platform to say what you want. It's, yeah, I agree with you. And what about this? And so it's this blurring of the lines. And I think if Fox gets tagged, it will be because of that line, that these weren't like the Chris Wallace who just left, who kind of think for the most part kind of tried to play it straight at news at Fox and report the news, and got intolerable and he left. But these people were sort of hosts, and we're pushing these false narratives. And if they get tagged, it'll be because I think that they crossed that line from being less like Chris Wallace and more like people who were like the people that they had on their shows, that they were pushing this narrative. And if you're pushing it, then and you're endorsing it, and you're making those statements, then you're essentially are going to be held responsible for it. And so that's where I see the issue with the entertainment and the news convergence being one that could come back to hold those people accountable.
Good. All right. Well, we are running short on time, but I want to ask Jared another question, and then I'm going to end up with allowing each of you to have sort of the final word. George, we'll start with you and then move down the line. But Jared, before we get to the final word, I wanted to ask you, following up on Mark's question about sort of the news environment and the confusion with entertainment and opinion. What do you think, or how can journalists make sure that the hard work they're doing, like what you're doing, sort of rises to the top? Or can they?
Yeah, I don't know. I mean, it's I think that media literacy is a huge problem that we have. I'm constantly surprised that people take news content that seems purposely knee-jerk and outrageous at face value without looking into it more. So I don't know what we can do. I guess just keep doing good work and try to keep our names clean, while other these other sources of information might falter along the way. But no, I think we need to teach people how to be better news consumers.
Good. All right, George, here we go. Some parting thoughts, please.
Oh, yeah, that's well said. I'm a huge fan of media literacy also. I mean, we need to be better consumers, I guess, of our media. I don't know, it's not a disclaimer necessarily, but people need to understand that these cable news shows, quote unquote, in the evening, that people take verbatim, really are not news at all. That's that blur that we were talking about earlier. That's entertainment, folks. And the hosts themselves are the first ones to prove that up when they get sued, when they go to court. Rush Limbaugh did that. I mean, the first words out of his attorney's mouth basically was, "Hey, this is entertainment." Everybody that tunes in Rush knows he just runs off at the mouth and just says whatever he wants to. And they know that a lot of this stuff isn't true. Well, the fact of the matter is, I think the majority of the people that listen to Rush Limbaugh, and what an influence that man had on America over a 20, 30, 40-year career. I think a lot of those people thought everything on there was true. I think they thought it was news. And on the other side of the political spectrum, you can say the same thing about Rachel Maddow and people like that. They just are not capable, like Jared says, of this media literacy to be able to discern the difference between pontificating entertainment and factual news content. So, I try to make that painfully clear on my show. I try to present it in an entertaining fashion so that people will be likely to tune in again and get something from it. But keep my nose to the grindstone and keep providing straightforward, good news content and good guests on my show. And as long as I can continue to do that and not have to quit out of the fear of being sued, for a libel or something like that, I'll keep doing it here as long as I can in retirement. So thanks again for having me on the panel.
Thank you. All right, Jeff, you get a parting thought here. I do want to say, for the record, you probably want to, stay in business and keep working. So this might be a trick question for you, but let's hear your final thoughts.
I've got plenty of work. There's always people that are suing the press or suing people who are speaking up and criticizing government. But I mean, I'll just bring it back to where we started. I just think that we take some of our fundamental freedoms for granted, and New York Times versus Sullivan is one of those, anthems to press freedom and the role that the press plays in a functioning democracy. And there really is nothing else like it out there. I mean, when the Supreme Court had that case, they put the thumb down on the side of more speech, not government being able to crack down on speech. And so we are the most press friendly and speech friendly country among all the modern democracies. There's nothing even close to it. You go over to England, they still have the common law libel rules over there where damages are presumed and you got to prove the truth. And that's why all the libel people who are powerful, the oligarchs and all those folks, they sue in England because they know they can win there because they don't have a First Amendment, and we do. And so we're very, very grateful that we live in a country that has a First Amendment. But it's like everything else, you can't take it for granted. You got to keep fighting for it. We got 2 justices that want to roll it back, and so I'm just honored to be here with George and Jared to do the work every day of independent journalism that New York Times is designed to protect. And keep on doing what you're doing. You're the ones that inform people and allow us to participate in government. So thank you, and thank you, Julie.
Thank you. All right, Jared, we can't forget you. The last day of your 29th year, is that what you said?
No, I'm 40.
39th year. All right, well, you don't look a day over 29.
All right, well, thank you.
Yes.
No, thanks for having us here to talk about this. Obviously going through, being sued for libel, this is an incredibly interesting topic for me. Jeff and I, the one thing I think we can improve upon, at least in the state of Iowa, Jeff and I were talking about before, was to pass a law that would allow newspapers or other media organizations to recoup attorney's fees so that there's not any sort of incentive to file a frivolous lawsuit. Anti-SLAPP. There's been some talk about at the state level, but nothing's happened yet. We prevailed in our lawsuit. It went on for 8 or 9 months. We were fortunate that we had insurance to cover a lot of that. But if we didn't, we didn't even make a trial, and our attorney's fees were in excess of $100,000. It would have easily doubled had it gone to trial.
Lawyers have to eat too.
Thank goodness for the lawyers we had. But even you go to trial, you don't have insurance. Even if you win the lawsuit, you still might be, you might be sunk. Your newspaper might go bankrupt. So that's an area we can improve upon. But yeah, no, thanks for the chat today. I enjoyed it.
Right. Thank you, everyone, for hanging with us as we went a little over time. I want to encourage you to continue the conversation and the discussion tomorrow. We have a full morning of First Amendment workshops on topics that are just as contemporary as this one. So check our website for more details. And I want to say thank you to each of our panelists. Thank you to the Zoom audience and the audience here in the auditorium. And we'll close with a round of applause.